And welcome to our webinar on the Advanced Practice Update on VAWA and U visas. My name is Amy Chung. I am a Senior Legal Counsel at ASISTA Immigration Assistance, and I am joined today by my wonderful colleagues Laura Flores-Bachman and Cecilia Friedman-Levin.
Hi, everyone. Hello.
And for today's webinar, we are very grateful for the support of the Office of Violence Against Women, which has provided funding for our OVWTA work as well as today's presentation. Just a couple of housekeeping notes. As Stephanie mentioned, there's a chat box where you can put in questions. There's also a hand-raising function. There should be a little person with a hand raised on the upper left-hand part of your screen. So there may be points during the webinar today when we'll ask folks to raise their hands in response to a question so we can get a little audience participation. We'll also have some polls and discussion points throughout. And then finally, there was, if anybody is seeking CLE credit for participating in today's webinar, we have been approved for 2 hours of CLE credit through the State Bar of Texas. So if you're barred in Texas, you should have included your state bar number in the registration form. If you didn't, then you can email us after the webinar today and we'll get you added to the list. If you are barred in a state other than Texas and you're seeking a certificate of attendance to submit on your own behalf, then just shoot us an email after the webinar and we will get you connected with that. And without further ado, let's get started. So for today, what we're looking to do is to identify case law updates and policy and practice updates in VAWA and U visa cases. And so specifically, we're going to be looking at rejections of U visa filings for leaving spaces blank on the 918 and 918A, obtaining continuances in removal proceedings for people with a pending U visa petition before USCIS, some common RFE issues that we're seeing in VAWA and U visa cases, options for liaison support through various government agencies and offices if you're having an issue on a case, and also what to do if you are missing a USCIS notice. In particular, missing RFE notices, NOIDs, and potentially even denial notices. Okay. And with that, let's turn it over to Cecilia.
Hello, everyone, and thank you, Amy. And I definitely hope that you and yours are staying safe and healthy during this really difficult time. So I apologize if you hear small children, because I feel like that might be the situation of many of us in terms of pets and children and other people who might be home with us today. So I apologize in advance for that. But we're going to get started and talk about blank spaces for rejections of U visa applications. And so what I mean by that, if this is something that is that on December 30th of last year, the U.S. Citizenship and Immigration Service put on their website, specifically on their website for the I-918 U visa petition, this alert that says that they may reject the Form 918 or the Form 918 Supplement A if there's a blank field unless the field is optional. And they said that optional fields can include safe mailing addresses and fields that only should be completed if the initial answer is yes to a previous question. That they have to have a response to everything, even if the response is none, unknown, or not applicable. And so they said they will reject forms if they have an empty field for a middle name, for current immigration status, or anything related to a spouse or child. Now this is when I'm going to have Amy mention that the hand-raising function. How many of you have received rejections of U visas in the last few months due to blank spaces? All right, so several of you have had this happen. And this is something that has recently now applied to T visas as well. On March 16th, a similar alert went out on the T visa website on the 914 page with the same policy, right, that there would be rejected for blank spaces. And so what is interesting about this is that this was posted on December 30th, and then later on January 22nd, the CIS Ombudsman also put out an alert saying that they should put a NA or something in each field, even if it is optional, right? So it seems like that they are even encouraging advocates and applicants to go and just basically put something in every field, even if it's optional or what USCIS deems optional, that every field should have something in it. So what does this mean, and what are the impacts of this policy on survivors? Why don't we go ahead and think about some scenarios that we have seen at ASISTA that have come down. So for example, on December 27th, we filed a U visa application for our client. She has no middle name, doesn't live in an apartment, so you left those spaces blank. And for the past decade, this has been an acceptable policy. So you left those blank, but you received a rejection notice on February 6th addressing these issues, and that there's a blank space regarding question immigration status, but you had filled out that space. And you get this rejection notice, but now your law enforcement certification, your supplement B, has gone beyond the 6-month period and has now expired. So some things that I want to point out in this scenario. One, what do we think of the date that it was filed? This is something that is, that we are considering as being something that's an issue because it was filed before the policy alert went on the 918 website, right? So this is kind of filed beforehand before this policy went into effect. What USCIS is saying is that this policy applies to applications that were received on December 30th, right? So if you have one of these cases, please do reach out to ASISTA for some liaison assistance, because if it was filed beforehand, this is something that we are raising up to folks in headquarters. So then again, something that we're seeing is that these rejection notices aren't coming out until probably about 4 to 6 weeks later, right, which is kind of opening up the concerns of law enforcement certifications expiring and some other issues which we'll dive into later on. So oftentimes, we have seen too that if you don't have a middle name or an apartment number, I think the concern was that we didn't want people having work permits with a middle name NA, right, or none. And so this is kind of a way to say that it didn't apply, is to leave it blank. But that is not going to be acceptable under this policy. So putting something in this field, we're going to discuss what to put in those fields in the next slide. But also, it seems like there's a problem. What do we notice about this current immigration status, right? What is something that's problematic there? Right? There's a mistake, right? And that, I think, is something that, when we're seeing errors in these rejection notices, we're going to think about how to approach those as well. So we have our first poll. What would you write in this middle name and apartment field? Would you write none? Would you write NA? Would you leave it blank, right in the margins? Are you unsure? Is this something that is just like boggling your mind at the moment? Would you do something else? Maybe you would put everything. Or what do you think would be your approach? All right, so we're going to give folks another 30 seconds to to respond. All right, we can end the poll. Okay, let us see what people say, if we can, if these people can see it. So the vast majority of you would write NA in the middle name and apartment field. What do we think about this? Amy and Laura, would you do the same thing? Would you put NA?
I would.
Yeah,
But
I think
this
that,
is, it's based primarily on what we're seeing in the rejection notices, right?
yes. And so some people have said that they would, you know, if they put in none, then they got kicked back because they didn't see NA. And so I think based upon what we're seeing in the rejection notices, that putting NA, if there is no middle name or if there is no apartment field, is the better way to go. And I think that sometimes you write, you know, there's been this prior practice of putting in lines and fields that don't apply, or putting in like big X's if sections do not apply. And to my mind, and the best practice would be to write something in the field box, because we have seen rejections where there have been those kind of sweeping, you know, crossing out different sections or lines that I would write through. I would write something in every section. So I think that that is something that for these fields of middle name and apartments, make sure that you're, one, putting something in these fields, and in that, I think that based on what we're seeing, USCIS wants to see NA in those fields. So again, I don't think that, you know, looking at the chat, it seems like people who are filling in lines, that those cases are getting rejected. Big X's for a section, for example, if there's no derivative, I think it's question 8 on the 918, you know, has all this information about family members, and sometimes you would just be able to put a big X through it, that is no longer going to be sufficient. So that is something that we have to, and again, as Amy mentioned, N/A, I think is something that we would recommend, making sure that you put that slash in there, or writing out not applicable if it fits. Okay, are there any other questions on this? Okay, if we can go to the next one, or I can do that. Okay, so what do the instructions say? And what is very interesting on this point is, now that this, all right, I'm going to get ahead of myself. I'm going to back it up. So the 918, this is what it says in the actual instructions. It says that if it does, the question doesn't apply to you, like if you've never been married, then write NA, right? And if the answer to a question requires a numeric response, to write none, right? The question is that you do have these fields where, for example, middle name, for example, apartment number, for example, A number, right? Where the correct response could be either of those things, right? And the directions itself, too, is that if you have, say that for Social Security number or for A number, that if it is unknown or you don't have one, to leave it blank, right? So I think that, you know, looking at what we have in terms of, there's a lot of confusion. There's a lot of confusion between, one, what the instructions say, two, how these rejection notices are coming back and saying what they're looking for, right? And then kind of what the instructions are directing. So I think that, and what the prior practice has been, right? So, and in the 914 space, that there's even less instruction about what is an optional field or what should be done. And so I think that making sure that we take a look at what it is that's available to us. And seemingly, these rejection notices have information and guidance that goes beyond, unfortunately, what we have in these instructions. And so something that we have asked for is kind of clarification around what it is that they're looking for, because it seems to be very inconsistently applied, as well as contain information that is not available to stakeholders. Okay. So I think what we recommend for best practices, if you get a rejection notice, to check it for mistakes. You know, I think that particularly if you have something like a law enforcement certification that has expired, or perhaps a derivative has aged out after you got the rejection notice, that you want to make sure that there are no errors, right? And if there are errors, when you do resubmit them, then I would kind of put on there as a cover sheet, maybe in a different color paper, for records supervisor review. Because this policy is as new to USCIS mailroom people as it is to us. And so I think that where there are problems, where there are errors, it is important to flag those when you are resubmitting them. To make sure that you maintain a copy of your initial filing for your records. So if you do have a client come in to sign a new 918 or 19A, that you have the initial copy of what you submitted initially, whether that is a scanned copy that you just kind of keep in your electronic files, or if you are resubmitting the original, maybe having the client re-sign, because if you're adding in additional information, but make sure that you have a copy of what you submitted initially. I think it's important to keep for your records. The other thing that I would encourage folks to do is to check that your other ancillary forms, so your I-192s or your 765s or your 485s or lo que sea, is a current version. We have seen rejections where now that they got kicked back and the version of the 192 that they submitted is no longer on the current edition date. So make sure that you're checking the ancillary forms and make sure that they are submitted, that they are current before you resubmit them. And you can include in your cover letter a request that USCIS accept or backdate the application to its initial filing. While I think it is important to make this request and to have it on record, it is unlikely they will actually do so. Especially we have seen cases that we have submitted, you know, maybe that were filed before this policy went into effect, that when they were resubmitted were not backdated. And I think that this is something that they're currently not doing, but I do not think it hurts to make the request, particularly if there are errors in your rejection notices, particularly if there are age out issues or something where there is a very kind of critical consequence of this new policy. It's just, I think, important to get on record and asking it. And then we can think about how ASISTA can kind of help you with the liaison assistance and how to elevate these cases. But I will say, and just to be straightforward with you, that even when we do kind of raise these cases to USCIS headquarters or to folks at the CIS Ombudsman's office, and we're going to talk a little bit later about how you can do these individual liaison requests, that the results that we're seeing is that the filing dates are maintained, the resubmission, and so that is what we're seeing in these cases. The other thing I will say that I think is important is that this blank space policy should not be applying to supplement Bs. So if you are seeing or concerned about blank spaces that you have in your law enforcement certifications, to my mind and to my knowledge, USCIS should not be kicking those back for those reasons. And if you're seeing that, I need to know that right away, right? So again, Kathleen asked if you have a basis to request the form be backdated if there are no errors in the rejection notice but the sub B expires. I think you have a basis, but whether or not they will do it is another story. And so we definitely, I think, want to make sure that if your law enforcement has expired, then we can think through how to get a new one. Which brings us to this one, is because this happens a lot. This happens in most of the rejections that are coming our way, and right now I have like nearly 100 cases. that the most common issues that we are seeing is that the law enforcement certifications are expiring. As you know, those certifications are only valid for 6 months from the date of the signature. This is a function of our of the regulations, right? This is not in the statute, but it's in the regulations that the supplement Bs are valid for 6 months from the date of signature. And I think the best thing to do is to contact your agency to try to get a new one straight away. You could try to refile a request that it be non-protunct, but again, the result is unknown. It is likely not going to happen. And I think what is also important is to consider whether or not you're pressing against other deadlines. For example, like if your case has been rejected and now you're pushing up against the 21st birthday of a derivative or the principal applicant aging out, right? That I think that, you know, what is the best practice in terms of refiling in those situations. And so I think it's just to be mindful of if there's other documents or other kind of deadlines, that you're considering, how those two things interact. Again, yes, please, Elizabeth, contact me about the sub-Bs because that should absolutely not be happening. Again, we are continuing our liaison assistance in these cases. We're considering our kind of other contacting the agencies with whom we work to let us know of these issues, and we're going to talk a little bit about how you can engage with them as well later on. So if we can go to the next slide. Again, we talked about age outs. We talked about expired forms. And I want to kind of take a moment now to kind of see what you're seeing and what you're experiencing. If you're not able to get new certification forms, like that is something that we would like to know. So if we can kind of say a little bit about kind of leave some space for you and to kind of in the chat explore what you've been seeing. So Alexandra wrote that she wrote NA in the Social Security number fields and had applications approved. That's great. That folks are able to get new certifications, so it's really good. And I think when you are reaching out to law enforcement for these new certifications, letting them know that this is something that is a circumstance kind of outside of your client's control, right? That there was this policy change. And so I think hearing about kind of how you are advocating with them is kind of, if you have strategies to share what was working. I'm glad to hear, Gabriella, that your agency was supportive. And so that's great, Amy. Amy says that there's a letter going out to talk about common sense policies and to extend supplement B certifications. And I think if I can, I don't know, Amy, if I get too off script, then rein me back. But that is something that I think is very important to kind of know, just additional hardships. I mean, immigrant survivors sit at a lot of different intersections of vulnerability, right? And I think that it is even more of the case during this pandemic in terms of accessing assistance and what this might mean for case processing. So this is something I think absolutely that we should kind of consider. So I think Elizabeth asked if she can address the NA versus none in our cover letters to potentially avoid a rejection for that reason. I think that this should only be coming up if you are resubmitting it. But what do you think about addressing this as a preventative measure, Amy and Laura? To my mind, it seems like saying, like, we put NA in the middle name field because our client does not have a middle name. Do you think having an explanation like that in the cover letter would be useful, or do you think because the people who are opening this file to check for sufficiency, to my mind, I don't know whether or not they'd be reading the cover letter?
So once upon a time, when I toured one of these mailrooms, and of course it's all different now, right? But the idea was that first line, contract workers who opened them really didn't look at the cover letters. That was for the officer. So they don't read the cover letters. They actually just look at the form itself and have a little checklist of what they are looking for. So unfortunately, I don't think it will help in terms of the frontline people. It may help if this is the second time you're submitting it and you've asked for supervisory review or something like that. Then at that point, if you actually get a supervisor to look at it, then that would be helpful for them to know, what your process was. But unfortunately, I don't think it gets you past the mailroom.
Right, I agree. Okay. All right. Now I'm going to turn it over.
Okay, thanks. We're going to switch gears a little bit. We're going to discuss U visas, pending U visas in removal proceedings, and asking for continuances in that situation. Next slide, please. Okay, so we'll start with a poll. In the last 6 months, have you filed a motion for continuance because of a pending U visa petition? Yes or no? Just trying to get a sense of, everybody's kind of practice areas and what everybody's experiences have been since several changes have come down the pike. So we'll give it just a couple more seconds. Okay. Whoops. Okay, so let's see, 67% no, and 23% said yes, you filed a motion in the last 6 months. So let's go to the next poll. So in the last 6 months, have you received a prima facie determination for a U petitioner who's in removal proceedings? Yeah, okay. Let's close this up. I'm going to give it just maybe one more second. Okay, so the vast majority of you have not received a prima facie determination in the last 6 months. And we're just trying to get a sense of what everybody's seen because the last 6 months have been really telling. So let's start with prima facie determinations. So prima facie determinations were essentially created as a protection against removal, right? When Congress created the U visa petitioners who were in removal proceedings, U visa petitioners with outstanding orders of removal, were also intended to be protected by the U visa. So because of that, a process was created through regulation and through policy where basically USCIS would do an initial review of the case, and if the person was found to be prima facie eligible for a U visa, then that person's removal proceedings presumably could be held, continued until a final decision was made on the U petition. Or in the case of a person with an outstanding order of removal, ICE would take that into account in determining whether to grant a stay of removal until the U petition could be adjudicated. And these regulations and policies with USCIS and with ICE, they kind of dovetailed informally with the EOIR prima facie system that was created by the BIA in the decision of matter of Sanchez-Sosa. Okay, so that's how things were working and were supposed to work and were in line with, congressional intent. So what is the current state of the prima facie determination? Well, it's a little bit different. What we are seeing now is that things have changed, right? What has happened since Sanchez-Sosa is we have had two additional BIA, one BIA and one Attorney General decision kind of warping the Sanchez-Sosa decision. And we've also had changes in ICE policy. So let's start first with ICE policy, right? So what did we have before? So before we had 2009 policy that was developed based on USCIS's regulations, which were kind of a roadmap, right? The regulations kind of included what Congress had intended the U visa, the purpose that Congress had intended the U visa to include, which was protecting those petitioners in removal proceedings and with outstanding orders of removal. So based on this USCIS roadmap and the regulations, ICE would, implemented a policy where they would communicate with USCIS. They would ask USCIS to issue a prima facie determination for those in removal proceedings, for those who are detained, for those with an outstanding order of removal. And from there, then decisions could be made, right? Decisions in court as to whether a continuance could be granted, decisions by ICE as to whether they would oppose a decision for a continuance or whether they would approve a stay. But in August of 2019, ICE changed its policies on prima facie determination. And so what changed was ICE eliminated the prima facie system for stays of removal for use with outstanding orders of removal. And so what that meant was they might take into account, if you included it in your stay request that there was a U pending, they might take that into account, but they weren't going to ask USCIS to make the determination, so that they won't do that step. And essentially they're going to look at the information that you provide relative to the U and all other factors that you include or that are present in your client's situation in order to make the stay, in order to decide the stay, I should say. So that's one part of it. And then the other part of it is, in most cases, ICE won't request a prima facie determination from USCIS for any use in removal proceedings at this point based on this new policy, or based on the August 2019 policy. So that's whether they are detained or non-detained. ICE will, however, and this is one silver lining from that policy, is ICE has indicated that they will not remove a U petitioner who is waitlisted, so who has been granted deferred action by USCIS and is on the wait list, unless there's new information since the time of being placed on the wait list. So if there are new grounds of removability that apply after the issuance or after being placed in deferred action and on the wait list, then USCIS can take that into account. But otherwise, they should not be removing. How has this worked in practice? Well, I think the big caveat here is that while ICE will not physically remove them, we have heard of instances where ICE will still pursue the removal. So in other words, they will continue with removal proceedings. They will, issue the NTAs if they have not been placed in removal proceedings. They will continue to present their cases before the immigration court for the removal of a U who is on the wait list. But if the judge then orders a removal or there is a final administrative order of removal, then ICE won't physically remove them. That's what we are seeing come out of some jurisdictions, not all. In other jurisdictions, we are seeing that ICE just will agree or at least not oppose motions to continue for those who are on the wait list. So what I will say is if you do have a situation where you have a U petitioner who is on the wait list and has not had a new ground of removability occur since being placed on the wait list, and you see that ICE is pursuing the removal in immigration court, contact us so that we can kind of see if there is something that we can do on our end in guiding that case with ICE, see if we can provide you with case assistance based on what we're seeing at that time. So that's ICE, right? What about what's happening in court? So we have Sanchez-Sosa, which in Sanchez-Sosa, the BIA established this general rule, right? The general rule was that that there would be a rebuttable presumption that a U petitioner who has filed a prima facie approvable U with USCIS will warrant a favorable exercise of discretion for a continuance for a reasonable time. So that was kind of the general standard. And under Sanchez-Sosa, the immigration judge, if these factors are met, shall consider DHS's response to the motion to continue, whether the underlying visa petition is prima facie approvable, and the reasons for the continuance and other procedural factors, right? But generally speaking, there was this rebuttable presumption, and then there was the other factors. And from there, we got matter of LABR. So in LABR, the Attorney General essentially instructed IJs and the BIA to consider all relevant factors in assessing good cause. So it didn't overturn Sanchez-Sosa, but essentially what the Attorney General said was, in order to continue proceedings, to accommodate the approval or adjudication of the collateral petition, then IJs and BIA should consider both the primary factors, which are likelihood that the respondent will receive collateral relief and whether the relief will materially impact the outcome, but also secondary factors, right? So the secondary factors were are respondents' diligence in seeking continuance or collateral relief, DHS's opposition or their general position on the motion, concerns of administrative efficiency, length of continuance, number of hearings, time, right? How much time are we asking for in this motion, or will it reasonably take? So after all of that, and still we were, able to show, right, U's still were getting continuances because that prima facie determination system had not yet been dismantled, right? So if you could still show prima facie determination and then you could get those secondary factors in play, then for the most part you were still seeing continuances granted. January of this year, the board issued a decision in matter of Mayan. So in Mayan, the board didn't disagree with the respondent was prima facie eligible, so Sanchez-Sosa requirement, right? And they didn't disagree that the grant would materially affect the outcome, which is a primary factor under LABR. But the board found that the primary factors are not dispositive when there are relevant secondary factors that weigh against continuing the case. So I think in this case what's happened is that even though we're still calling them primary factors, in Mayan, in this particular set of facts, the board found that the secondary factors, all of the secondary factors taken into account, outweighed the two main primary factors, right? So that's where we are in terms of prima facie determinations and in terms of continuances. So the question is, what do we do from there, right? What do we do with where we are now when we're asking for a continuance? So generally speaking, first, as far as prima facie eligibility, we should still be asking USCIS to make the prima facie determination because USCIS is the agency with the training and the jurisdiction over U visa petitions. They are in the best position to be making that determination. Now, granted, the regulations, the USCIS regulations, how they were set up was for ICE to make the request of USCIS. However, USCIS regulations have not changed. USCIS regulations still include the prima facie determination process, and so I think we should still be asking for prima facie determinations from the agency that is in the best position to do that. What else can we do? So here, on your screen, you're seeing some EOIR suggestions, right? Ask to be placed on the status docket if it's available in your jurisdiction. What we have found interesting is that it really isn't even by jurisdiction. It's judge to judge. Some immigration judges will maintain and still maintain a status docket. Some immigration judges will not and will point to an EOIR memo that came out on maintaining a status docket. And what we have found is you've got to ask. Even if you have been told before there is no status docket, what is a status docket? It is important to ask with each IJ if you don't know if that IJ has a status docket. Set up your case, right? Show that your client is prima facie eligible for a U visa if ICE is refusing to ask for a prima facie determination, and if USCIS has not issued a prima facie determination, then ask, show the judge the information, ask to be placed on the status docket. In the alternative, ask for a continuance and go through the matter of Mayan, the matter of Mayan decision, right? Show how in your client's case you can distinguish matter of Mayan, and your client is still eligible for a continuance. So prima facie determination, and that it will, the outcome will materially affect the outcome of the proceedings. So those are the two main primary ones, but then go into your secondary factors. Diligence, distinguish your facts from Mayan. If there was a delay between the qualifying crime and the U visa application, explain why. Get this on the record. There are many reasons, and I'm sure you all are very familiar, right? There are many reasons why a survivor is not going to, after suffering, from being a victim of a serious offense, they're not going to just run out from that crime to then filing for a U visa petition. So what was it in your client's case that can help you show that there was diligence in submitting the U visa application? In terms of another secondary factor as far as administrative efficiency, argue that denying the continuance and ordering the removal is not more efficient because the court will just have to adjudicate a motion to reopen once the U visa status is approved. Remember, going back to our congressional intent, U visa petitioners that were in removal proceedings or that are in removal proceedings were intended to be protected. So there is the ability to file a motion to reopen because a U visa can still be approved even if they have an order of removal, whether whether it's administratively final or if it's pending on appeal or et cetera. So it's not more efficient for the court, for EOIR. And then the other reason is delay in U visa proceedings is USCIS's delay, right? Unfortunately, USCIS has an extensive backlog, and that backlog is not the respondent's delay. So it's important to get that on the record as well, right? Okay, this is the adjudication timeline, but that adjudication timeline, if my client's case were adjudicated, the client could get on the wait list based on USCIS regulations, and if they got on the wait list, they would get deferred action based on USCIS regulation. And if they got deferred action based on ICE policy, ICE would not be pursuing removal. And so it wouldn't be administratively efficient for the immigration judge to discount all of that just because of how long it takes USCIS to adjudicate an application. What ICE sometimes focuses on is not the adjudication of the application, right? But we've seen them focus on what? On the issuance of the visa itself. They say, you know, there's only 10,000 a year and there's no visas available this year. Most of the time, for other forms of relief, if a visa is not immediately available, immigration judges will say, well, a visa is not immediately available, so even if the visa was, the petition was approved, you still would be subject to removal. And so it's important for us to focus on, yes, that's generally true, but the U visa is a different category, right? The U visa, USCIS did put into effect this deferred action process and the wait list because of the fact that Congress intended to protect victims in proceedings and to protect victims from removal. The idea was not to let them be removed and then continue the application process. While we know that is an option, that wasn't what Congress intended the process to be, right? So I think, unfortunately, it does take a lot of education right now when we have to focus really on honing our arguments a little more. And I know IJs are not, they're under a lot of pressure. And so sometimes they are not wanting to really take all of this into account. It's really helpful to have these motions written out and have your arguments written out so that if you're not able to make all these arguments on the record during the hearing, that you've presented them and you have them on file in the event that you have to set yourself up for a BIA appeal. So I've kind of got into a lot of detail there. I think the final thing I'll just say is there's additional information on ASISTA's website, amicus brief that we have submitted recently in a Sixth Circuit case. We also have samples and other resources, so please do look at asistahelp.org in our resource library. And if you have case-specific questions, don't hesitate to reach out to us through our technical assistance. But before I close it out, I also want to know what has worked. Has anybody, just in the chat box, has anybody filed a motion to continue recently with your immigration judge where the continuance was granted after matter of Mayan? And if so, what have you used? Okay, so we have a couple of people that said yes. I'm going to give them a couple of minutes to let us know what worked, what arguments worked in their jurisdiction. I think one of these jurisdictions is Houston, so let's hear what worked in Houston. Let's see, someone said that, Angela says, yes, they filed a motion to continue, but it was based on a pending T visa. They used the matter of Mayan in their footnotes, and this was granted. So was it granted in San Antonio? The T visa continuance that you filed? Yes, it was granted. Okay, so that's really good to know. And Deepa says that she has done an oral motion at a master and had no problem getting a continuance, and there was no opposition from DHS. Wow, that's really great to know. So you see, you have to keep on asking. And Angela also says that they didn't receive any opposition from DHS. That's really helpful. That makes my heart feel better because, of course, since we do technical assistance, we hear a lot about the problems, not the wonderful outcomes. So it's really great to see that there are several of you saying you got continuances, and someone points out that it was very easy to distinguish matter of Mayan, so that was important to do. Yeah, and I do think that has to be your focus. So I think I'm going to leave that conversation there, but if you have specific case information that you want to kind of mull over, yeah, please do contact us through TA, and we'll keep this conversation going. But for now, I'm going to go ahead and move this over and send it to Amy, who will talk about some RFE issues that y'all may have been seeing.
So just before we move on, I want to flag for folks that there was a very interesting exchange in the chat box where one person whose U visa was filed in January 2018 recently got on the wait list. And what seems to have happened is that the immigration judge pressured the ICE attorney to get the case expedited. So even though under the August 2019 ICE directive, ICE is no longer engaging in the prima facie determination process, there's nothing in that directive stopping ICE from continuing to request expedites from USCIS, which is a completely separate thing. And
Thank you.
It's very much jurisdiction by jurisdiction. So we've heard from lots of folks where their OCC will not request an expedite. And then we've heard from other folks that ICE will do it, sometimes even without the immigration judge pressuring them. But certainly if the immigration judge does put pressure on OCC, that would not hurt. The other thing is that even if there is another agency, such as an AUSA or something, some other kind of federal government agency putting pressure on ICE or on USCIS to get this expedite done, that can also be very effective. So it's useful to think about who else can help put the pressure on. And then also keep in mind that you can also request an expedite on behalf of your client, but in general, those are quite difficult to obtain. But if your client or your client's dependents do have, for example, really severe urgent medical needs, that can be sometimes a compelling basis to get USCIS to do the expedite themselves, even without ICE making the request. So all of these things to keep in mind.
Thank you so much for that follow-up. Yes, that was super important. And I just want to also point out if some of you are asking for additional details. So if you take a look at our practice advisory, which I believe came out in February, our Matter of My Own Practice Advisory has additional tips and citations and links to other resources, so please check that out as well. But thank you everyone for your awesome feedback on what's going on in your courts.
All right, let's move on to RFE issues. So we're just going to be talking about some of the very, very common RFE issues in U visas and VAWAs that we've been seeing these days, and some issues that we wanted to flag for folks in case they're going to start coming up for you as well. Okay, so let's pull up the poll. All right, so when USCIS requests a police report for your client, what do? Do you submit it, withhold it? It depends. Or perhaps if USCIS has never asked you for a police report, if you guys could answer the poll, and then we'll just give it a couple seconds for the responses to come in. Okay, so I'm going to go ahead and end this poll. So we've got a mix here. So we've got some people routinely submit it. There are a few who routinely withhold it. Some people say it depends. For those who say it depends, if you wouldn't mind sharing in the chat box, what are the factors that you take into consideration when you're deciding whether or not to submit a police report that USCIS has requested? So one person says that their state doesn't release police reports without a subpoena, so that's an easy reason to give to USCIS. Yes, there is a regulation saying that if the information, if the record is not available and you can document that, ideally through a letter on letterhead from the agency saying that it's not available, then that should theoretically be sufficient. One person is asking, is a police report like a background check of the crime? We're asking specifically about the arrest report or the incident report. Okay, so other factors that are going into the it depends category, anything that's prejudicial to the client. Typically, arrest reports may be prejudicial. Sometimes they're not that bad, right? Sometimes the arrest report isn't available. Right, so it depends on the nature of the information in the police report. How prejudicial is it, right? So that's oftentimes the main issue that people are looking at. All right, let's move on. And then out of curiosity, if people wouldn't mind raising their hands, has anybody had a client who had arrests, but where USCIS did not request the police report? And let's say within the last 8 months or so. So you had a client who has been arrested, but USCIS did not request the police report. So I've got a couple hands. One person says that USCIS only requested the disposition, which is what we want, right? We think USCIS should only be asking for the dispositions. All right, so there are a couple here. I think that this is reflective of what we've been seeing most often, which is that if somebody has been arrested, it's very likely that if you haven't already submitted the police report or the arrest report, that you could very well get an RFE for this information. Okay, so the issues that we're seeing are that in these RFEs, USCIS is requesting these police reports even if the client was never convicted. Let's say charges were never pressed, or if they were, the charges might have been dismissed. USCIS is still requesting the police reports. And what USCIS is saying is that the arrest affects the discretionary analysis. And so they're not necessarily considering the arrest in terms of inadmissibility triggering 212A grounds, but rather how does it factor into the discretionary analysis of the I-192 waiver or the adjustment of status, whichever the discretionary benefit is. And then the problem that we see in the actual adjudications is that USCIS often accepts the allegations in the police report as being true, regardless of what actually happened with the case. But then at the same time, for those who withhold the police report, USCIS has at times said that the withholding of the police report itself is a negative discretionary factor, and they have denied discretionary benefit applications on that basis. So what do you do? As people were saying in the chat, whether or not somebody decides to submit a police report or not is probably going to depend on the circumstances of what the police report says. And so there are some arguments for withholding police reports. So for example, one that a lot of folks use is that the uncorroborated police reports are inherently unreliable. There's a lot of case law to support the idea. And the basis for this is that police reports are hearsay, right? Like there's no opportunity to have the officer who wrote the report testify about their observations. Sometimes the police officer didn't actually observe anything, and what's in the report is based solely on the account of the accuser. And so that's even second-degree hearsay, right? That's not even hearsay of the police officer, it's hearsay of the alleged victim of the crime, right? And so there are additional issues relating to reliability if you're looking at a police report with that kind of fact pattern. And so if this police report is inherently unreliable, then how is it justifiable for USCIS to accept this kind of information in the police report as true, right? And then because it's inherently unreliable, that's why it normally doesn't it's not normally included in the record of conviction. And also, of course, as we all know, they can be very prejudicial depending on what's in them. But then, as I said earlier, USCIS might consider withholding it as a negative discretionary factor, right? So there are obviously lots of reasons why people might not want to submit these, but then there are also some problems with withholding. I'm seeing that the chat box had to be cleared because it was full, but just so you guys know, the chat information is saved, and so we'll still be sending out the transcript and everything in a follow-up email next week. So if you wanted to refer back to that information, it'll still be around. Okay, and then there are also times when people might decide to go ahead and submit the police report, right? So as some of you guys said, some of the police reports are really not that bad. Some of them are pretty bare bones. The information that's in there might be information that would be really fine to go ahead and disclose. And they might even be consistent with what your client is saying, right? And especially in that case, if the charges were dismissed or if no charges were ever brought, then you may have a stronger argument to say that your client actually didn't do anything that was that bad. And then the other thing to keep in mind is that USCIS is very, very interested in having folks show responsibility, like taking responsibility, showing remorse, and showing rehabilitation from their past mistakes. And it is perhaps a bit easier to show these things if you're submitting the police report, if your client is acknowledging what they've done, but at the same time, you know, there are reasons for somebody perhaps not to fess up to something that they've never been convicted for, right? Okay, so there are lots of differing ways to address this thing, this issue. We're not going to tell people one way or the other what they have to do. There is no one right answer to this. And we get this question in TA all the time. Ultimately, there are reasons to go to submit. There are reasons not to submit. This is a calculation that you have to make with your client as you're going through the case. One thing that I will recommend is that if you know that your client has an arrest history, it's a good idea to get a copy of those police reports if they are available before your client makes any factual statements about what happened in their affidavit. Sometimes folks don't have the arrest report at the time that the client is doing the affidavit, then they submit the affidavit, and then they get an RFE for the arrest report, then you get the arrest report, and then you see that the accounts are very, very different. And sometimes it can be difficult to reconcile the issues. Okay, let me see if there are some questions. There are a lot of questions here. So, do we think that USCIS would use the unreliability of police reports to question the evidentiary value of a 918B based on a police report? Oh, interesting. We have not seen that happen at all. USCIS overall seems to be quite convinced of the reliability of police reports, even though obviously we think that that's incorrect. So we have not yet seen them question a 918B just because it was based on a police report as opposed to criminal prosecution. Okay, and then we have another question. Are we opening the door by submitting police reports even where favorable or not damaging? We have a duty to the individual client to do what's best, but by submitting, are we letting USCIS make inappropriate requests? I mean, it's a judgment call, you know? I think that ultimately, attorneys owe a duty to their client, and clients have to understand the potential risk of withholding a police report. And the potential risk is that that's going to be considered a negative discretionary factor and that the relief could be denied. The client could be in a position of filing a 290B. If the client's not in proceedings, they could be in a position of being NTA'd. These are all risks that the individual client has to be prepared to take on if they're not going to submit the police report. So there's that. There's also what is everybody's individual capacity and what is the client's capacity for pushing the issue, right? It takes a lot of resources to do that. So I think one of the other approaches that we've seen folks take is that if they're submitting the police report, you can still include an argument in your cover letter about why the police report itself is unreliable, why USCIS shouldn't be relying on it. Okay. There's a lot of room for discussion about this issue. Okay, just in the interest of time, we're going to keep moving on here. So one of the other issues that we see quite a bit is where the qualifying crime that's been certified, whether it's domestic violence, felonious assault, whatever it is, where USCIS is saying that that qualifying crime does not match up with the statute that is listed on the police report or on the 918B. And so, for example, your client has been the victim of contempt of court. And this contempt of court arose from the abuser's violation of a protective order, and then she filed for a U visa, right? And so normally a protection order is civil. In many places, folks aren't able to get a certification based on the protection order itself. But if the protection order is violated, then in many states that is a criminal violation called contempt of court, right? And so then the client files for a U visa and the supplement B lists domestic violence as the crime. Great. But then the police report and the charging documents list the crime as contempt of court. And so then you get an RFE saying that contempt of court itself is not a qualifying crime. And so now you have to explain why this is a domestic violence crime, right? Because contempt of court is not listed on the list of qualifying crimes under the statute. So in the scenario, how have folks made this kind of argument? Well, first, if anybody has actually gotten an RFE on this kind of issue. And then second of all, if you did, how have you made the argument? Okay, so one person says that they use the substantially similar argument. And so in the list of qualifying crimes under the statute, there is a kind of catch-all that says that it also includes crimes that are substantially similar to the qualifying crimes, the enumerated ones, and that they would compare the elements between the contempt of court and domestic violence. So that is one approach. There are other folks who've gotten an RFE on this issue. Claire says that she relied on the fact that the abuser was ordered to DV classes and ordered not to have contact with the client. So even though the charge was actually reckless driving, it was a DV situation. Great. So you're looking at the facts there to establish that it's domestic violence. So our approach to this is that we would compare the qualifying crime, in this case domestic violence, to the facts of what actually happened, the fact that she had to get a protection order that he violated, and also the elements of contempt of court. We call this the category approach. And essentially what we're looking at is you look at the definition of the qualifying crime. So if you're looking at domestic violence, in most states, I would probably say every state, but I also haven't looked at every single state's entire criminal entire penal code. So I can't say that for sure, but I've never heard of a state that had a crime that was defined, that was titled domestic violence. Normally what you have are a bunch of criminal statutes where if the facts support it, then it would be a domestic violence crime, depending on the relationship between the perpetrator and the victim, right? And so what you're looking at for domestic violence is you would look under the statute for the relationships that you would need to establish domestic violence crimes or intrafamilial crimes. And then you would look at the definition of the crime that is being listed on the 918B, so the statute. In this case, it would be contempt of court. And then you're looking at the elements between the two of them, and you're seeing if they match. And if there are elements of domestic violence, as defined in the statute, that are not met by contempt of court, then you're looking at the facts of what happened to see if those facts would cover it. Okay, so for example, let's say the domestic violence statute requires there to be some kind of familial relationship between the perpetrator and the victim, but contempt of court does not require any kind of familial relationship. Then you would look at the facts of the crime to say, even though the elements of contempt of court don't require this relationship, we can establish through the facts that there was this relationship. In the police report, it says that the perpetrator had X relationship to the victim, right? And so you would use this combination of facts and elements to compare to the qualifying crime. And we think that this approach is more favorable and is also justified. So USCIS itself in the regulations and the final rule says that crimes are categories, right? And so that's one of our legal foundations for saying that this is a viable analysis. But then also, when you're comparing this approach, this category approach, to the substantially similar approach, the category approach would open up eligibility for more people. Because under the substantially similar approach, USCIS uses a very straightforward element-to-element comparison. So they're using strictly the elements of domestic violence and then the elements of contempt of court, whatever those might be. And if there isn't a correspondence between each of the elements, then they would say that those crimes are not substantially similar. Whereas the category approach adds in the possibility of using the facts of the underlying crime to establish that the qualifying crime has taken place. Okay, and so we do have an amicus brief on this particular issue on our website, as well as an AAO decision where they agreed with our analysis in that particular case. It was an unpublished case, so things will be case specific. Okay. And this should work for other categories as well. It's not limited to domestic violence. So we actually see it more often in felonious assault cases, where the crime has been certified as felonious assault, but the statute that was being investigated might have been robbery or something else, right? And so for this, what you would look at are whatever the elements of felony assault are in that jurisdiction, and then you would compare those elements to the elements of robbery in addition to the facts of what happened. And you would be looking for a correspondence there to cover all of the elements of felonious assault. Has anybody else seen this kind of issue come up for other types of qualifying crimes? Felony hit and run. Were you trying to get it certified as felonious assault? Okay. And did you make the category analysis in that case, or how did you handle it? So the category analysis didn't work in that case. So we'd be interested in taking a look at that. This is one of those things where you have to fight the battle every time. So making the case to USCIS it's not something that officers will necessarily understand the first or even the second time they see it. So this is one of the ones where if you're having this kind of issue in your case, we would encourage you to let us know, and hopefully we would be able to help you frame the argument and present it. But and then, okay. But you could theoretically apply this analysis to any kind of qualifying crime for U visa purposes. Okay. All right. And then let's go on to discretionary issues at adjustment. Let's pull up the poll. Okay. So we're talking specifically about U visa adjustments for the next few slides. So in the last year, Vermont has RFE'd a U visa adjustment on discretion where all negative discretionary factors were disclosed and addressed prior to the U visa grant. So we've been seeing a lot of these cases where they will issue RFEs on issues that predated the U visa grant that were disclosed, but sometimes the person also might have an arrest or something after the U visa grant. But we're particularly interested to know if folks have had cases where all the negative discretionary factors were disclosed and addressed prior to the U visa grant. So it looks like we're about half and a half here. Okay, I'm just going to go ahead and end this poll. So we've got 54% say yes, 45% no. The difference is only 4 people, so it's pretty close to half and half. We've seen a lot of RFEs where they're asking for information about issues that did predate the U visa that were addressed and disclosed. If it was a waiver of if it was a grant of inadmissibility, the ground was even waived on the 192. And then come time for adjustment, USCIS is asking about those same issues again. And especially if there have been any additional negative discretionary factors arising since the grant of the U, then that's even more likely to be an issue. All right, if we could, great, thank you. And so, yeah, this is the problem that we're seeing here, right? And then the basis for this problem is that adjustment for U's is discretionary, right? And so it has to be justified on humanitarian grounds to ensure family unity, or it has to be otherwise in the public interest, right? And so this is what USCIS is supposed to be looking at when they're adjudicating these U adjustments. Okay, so in terms of best practices, there are a few ways to handle this. So in terms, there are legal arguments to address this, and then there are always the standby factual strategies as well, right? So in terms of legal arguments, one that we've been looking at is whether you can argue that the standard for the 192 waiver, which is it has to be in the public or national interest, is actually stricter than the adjustment standard, which is humanitarian grounds, family unity, or public interest, right? And so seemingly humanitarian grounds, family unity, or public interest would be more generous than just public or national interest. And so how could it possibly make sense to say that the waiver is warranted and the standard is met under the public or national interest when it's not met under the more generous standard, right? And if that's the case, then you might have an argument that it's arbitrary and capricious to grant a discretionary waiver under a stricter standard and then deny under the more generous standard, right? The other issue that we're encouraging folks to raise is that the congressional purpose behind the U visa was to provide safety and security to cooperating victims. You know, there's no reason why it would make sense from a congressional purpose standpoint to make it harder to adjust status for U non-immigrants, for these cooperating victims, than it was to give them the U visa in the first place, right? The U visa was intended to be to provide a pathway to adjustment of status. One person is saying that she's argued estoppel, and the exercise of discretion doesn't mean that the decision can be arbitrary, inconsistent, or dependent on intangible or imagined circumstances. Certainly, if USCIS is making allegations that are not based in fact, then that would certainly be a basis for opposing. And then other folks are saying that they're getting RFEs on all U adjustments if there's any criminal history, regardless of before or after the U visa grant. That's pretty consistent with what we're seeing as well. Okay, in terms of a factual response to this kind of RFE, it's very similar to what we would suggest in the 192 context. So USCIS is very interested in seeing that the client is taking responsibility for their actions, expressing remorse, and showing rehabilitation, right? And so if you can provide specific evidence of rehabilitation, of their positive contributions to the community, and here we're talking about a focus on what they're doing for people and what the community would lose if they were to be removed, as opposed to just what the client would lose if they were removed, right? So certainly it's important to talk about what the hardship would be to the client, but it's also really important to talk about what the client does for the community, why the client's presence in the community is a good thing, and why they deserve to stay here, and why their presence sorry, is beneficial to the community. Okay. All right. All right, so from here, let's move on. And I believe next up is Cecilia.
Yes, thank you, Amy. And I am going to be talking about how, given just the overwhelming problems that we are seeing in the adjudication of these cases, everything from processing delays to what legal standard is being applied, and what due process issues we might see, and I think that we can figure out a little bit about what tools are in our toolbox in terms of administrative advocacy that we have at our disposal. So what do we do when we're stuck, and what are some options when we're just getting a result or not getting a result in a way that we think is fair or warranted of our cases? So many of you know, as OVW grantees, that you can reach out to ASISTA for our case intervention and liaison assistance. Given that we have been in the game for over 15 years, and our executive director, Gail Pendleton, is kind of one of the co-mothers of these forms of relief, have deep institutional connections within folks within USCIS and other government agencies to raise the systemic issues that we have, that you're raising, right? This re-adjudication of U adjustment of status, of all of these issues and things that seeing so often. And where in particular do we have those inroads, and where do we kind of work most directly? That is, with the Vermont Service Center, with the U Visa Work Share at the Nebraska Service Center, within folks at the Office of Policy and Strategy at USCIS headquarters, and within ICE headquarters. And the thing that I want to know about is important, I think, for you to know about our liaison efforts, is that we are able to kind of present information and problems to them. Whether or not we will get a response is a totally different issue. Sometimes you will see the result of our inquiry in the results in your cases, and sometimes they will just go into the ether and we won't know one way or the other. But one thing is for sure is that I do not get kickbacks on my email or return, that it's kicked back. And so at least I know that the messages that we are sending are getting to them. That's a very good question. What about consular issues? And I'm going to get to that in just a moment, because I think sometimes, particularly with UNT visa cases, working with consular issues and kind of challenges is challenging. So I'm going to go a little bit about what we know, right? And kind of these are some other avenues, like besides ASISTA, where you can kind of raise your case questions. The first one is within the USCIS Ombudsman's office. And so this is a ombuds office that has kind of jurisdiction over USCIS matters. So you raised the question about kind of what happens with U visa applications abroad. If you're dealing with a USCIS office abroad, then the ombudsman could particularly have jurisdiction where it's the USCIS division that has kind of power decision-making over that case. But what we're seeing more and more is that USCIS offices abroad are being closed down, and so it is coming more under the consular umbrella. But if you are dealing with in a jurisdiction where you're facing an issue abroad and there is still a USCIS office, then that might be a way that you can kind of reach out with those issues. So what types of things can you reach out to them? Outside of processing times issues, if you got a rejection that you believe to be in error, and kind of whether or not you're just not getting any response from USCIS, and basically anything that kind of falls within the purview of problems within the Citizenship and Immigration Service. And what they're going to want to see before you reach out to them is that you utilize what existing tools are in your toolbox beforehand. Did you check the USCIS processing time on the website? Did you check with the VSC hotline or the NSC hotline? What have you done, or with your district office, what have you done on the ground level to make sure that the service is aware of your issue or concern? And so it's important to, both for the ASISTA intervention and also for the USCIS Ombudsman intervention, is to establish that groundwork, show how what you're doing to reach out to the agency isn't functioning. And that is what they want to see in order to kind of get involved in the case. Laura or Amy, before I move on, is there anything that you want to say about best practices for ASISTA interventions before we move on?
I would say that when you're emailing the hotlines, make sure that you're including your G28, just like some very basic things. Make sure that you're including evidence to back up what you're saying, right? So if you're saying that you responded to the RFE over 60 days ago and they haven't responded, then include evidence that you responded to the RFE by a certain time, right? Such as the delivery confirmation. And then also keep your messages brief, but include enough detail to explain what the issue is, but then also be polite, be civil. No all caps, certainly no insults or anything like that, because that's not going to make it more likely that they're going to respond to you or to be helpful to you.
And I would just add one thing. When Amy mentions, keep your email short, don't include all your arguments in your email. In other words, if your RFE included evidence and then now they're saying, if your RFE response included certain evidence and now they're saying you didn't include certain evidence, don't make all your arguments in the text of your email. They simply are getting so many emails that they're not going to have the opportunity to review everything you're saying in your email. Let your RFE response speak for itself. And so in the email, it would literally be, just a few sentences. This is what you say. This is what actually happened. See attached. What the problem is, what evidence you're submitting, and what you would like for them to do, right? So in 3 sentences, you should be able to summarize it for them. And then that gives them an idea. They can go and look at your attachments. They can pull the file and go from there.
No, I think those are really great tips. And I think that I would just echo kind of Amy's recommendation of just civility, right? In terms of just saying that if this is someone that you are asking for help, you know, that I think that you can kind of, you know, make the argument and be a good advocate. But I think in terms of tone, I think that matters a great deal to folks who are at these service centers. So that is the only other thing that I would just emphasize. Another recommendation that we can make is kind of reaching out. How many people have done liaison assistance with their member of Congress or with their senator? Can we raise your virtual hands if that is something that you have experienced doing before? Carly? Absolutely. Stephanie? Laura? Patricia? Great. Una? Well, okay, great. So it seems like a few of you. Anna? Have done this before. And so reaching out to your member of Congress is not only kind of applicable in the immigration context, but it's, you know, they do often liaison assistance or constituent services is what they typically call them, trying to address administrative or processing problems on administrative cases. So if you want to go to, here I'll put this in the chat box, you know, to your member of the House. So if you click on that, you can find out who your representative is. And oftentimes they will have kind of constituent service pages or how we can serve and help you. And so oftentimes you have to kind of fill out a form for immigration matters. They might have an immigration-specific consent of release information, which is going to have information about the applicant or the petitioner, if there's a beneficiary, depending on the type of application that you're dealing with. And they're going to want to know if you've contacted another elected official about this. So, for example, if you're reaching out to your member of Congress in the House, have you also reached out to your senator's office? And then kind of finding information a little bit about what the problem is and kind of what the remedy is that you are seeking. I think it's important to know, and you can also kind of include other documents and things to back up your case. And I think what I would say is that the person with whom you are dealing in these offices could be anywhere from the most experienced immigration liaison person in the universe to someone who is brand new, right? So I think someone, if you have a jurisdiction where you do have maybe a larger population or someone who is in an urban area, might have a lot of experience with these issues kind of depending on who you are, right? So I think it's why it's important when you're doing these liaison forms that you kind of state what the issue is clearly, right? And so that they have an understanding of kind of what it is that the problem is and kind of what the specific remedy is that you're seeking. And I think the advantage of doing this is my understanding is that these inquiries are prioritized in terms of getting a reply because USCIS often has a dedicated congressional liaison staff who handles these. And so I think that is what, kind of one of the reasons that you might want to pursue these routes is kind of having them do some issues where you are having delays, you can't get this response. But they also can, I think, be very useful if you do have an urgent situation for a client in detention and someone who is at imminent risk of removal, that they can often become involved. For those of you who have done it, so Patricia actually kind of think has a very good point of saying that sometimes they have a trouble with a client signing the release if a petitioner was at a child who is at the time of filing, right? Because they're only going to accept signatures from the folks who have who signed the original form. So I think this is something that we can kind of to explore a little bit more. But for folks who have done these congressional inquiries, I think we'd be eager to see what your experiences have been. Have they been successful? What was it helpful in putting together your inquiry? And I think especially for those who may not have done this before, sharing some practice pointers of what you've done and what results you've been able to achieve, I think would be useful, in particular folks who are this might be a new process to them. So please do that while we can kind of, while we'll move on and we can talk about the next one. And the next, what we're going to talk about, we're going to go in depth, I think, more in the next slide when we're going to do a very fancy screen share. So hold on to your hat, folks. Is the Office of Civil Rights and Civil Liberties, which is an office within DHS that investigates exactly what it says, violations of civil rights and civil liberties. So what does this look like? For example, they would investigate matters within USCIS if there is kind of a meaningful denial to access to immigration-related benefits or services. And this includes violations of the confidentiality provisions in the Violence Against Women Act. And so those are your 8 U.S.C. 1367 violations, where there is reason to believe that there was information disclosed to an abuser or a member of an abuser's household, that an agency relied on information solely provided by an abuser or a member of their household, and making a negative decision in their case, as well as the kind of the location protections that we have in 239E. So those is an office we can walk through a little bit more about how they also do work with ICE and CBP, and I'll talk a little bit about that on the next page. Okay, why don't we move on?
Cecilia, do we have an idea of how
Yes.
long it usually takes for any of these liaison options to respond?
Yes. So I think when you're looking at the yes and no, I guess I should say, or I'll give you my lawyer answer, which it depends. So particularly I think with the CIS Ombudsman and the case assistance, they do have what is called an expedite process. And so those are the ones that you can kind of see, and I think when you're doing your description, and we're going to talk a little bit about how to do that, that you can kind of say like what the urgency is needed. And like I think usually that is I think in between what is like 45 days, and am I getting that right, for that expedite request. But they have their so for the USCIS Ombudsman to get involved, if you've tried the U.S. customer service route and you've waited 60 days past the processing time, then that's when they recommend for you to reach out, right? And so I feel like it could take a really long time, but if there is reason to expedite, then you should say so. We're doing this, and they should get back to you sooner. But usually, I think it depends upon the volume. I think that there's just so many issues that oftentimes the ombudsman requests were taking months and months and months, right? And so that members of Congress, Martha says, that usually get responses within a week. And so I think that's amazing. And it kind of depends on the jurisdiction. If you're in a place where there might be a larger population, then that might kind of be determinate as well. So did not give you a good answer. Why don't we walk through some of these forms? If we can do a screen share now, and the first form we're going to go to is the USCIS website. Gisela, you said the ombudsman took 3 months, but you got USCIS to reverse the denial. Okay, so it took a while, but I think ultimately the result was favorable. That's great. And so walking through a little bit, this is the, again, it's dhs.gov, CIS Ombudsman. And again, this is a component within DHS. that kind of focuses exclusively on kind of issues and delays and problems within USCIS. So if you go to case assistance, as Amy is telling me to pick up the pace, you can, again, they want you to reach out for help first, and this is how you do it. You can submit a form electronically, but usually it says if you're asking for benefits on the VAWA URT program, that they want you to kind of submit a paper to download the form and to have the client sign it, just because they are dealing with confidentiality issues as well. And so if you can kind of go to the form, I had to download it, Amy. So if you want to go to the download and then kind of open it, that might be a way to do it. This is what I had to do because I also got this screen. So just go to downloads and then open it up that way. There we go. And again, it is the same information that you would submit on the online form in terms of the names, what is the problem, if you're experiencing difficulties with USCIS, and kind of what have you done in the interim to try to resolve it. You're facing delays. It's also, I think, important to, if you're facing maybe kind of derivative age outs abroad for 929, this might be a way to help speed up those cases, and then doing the descriptions and what you've done in the past to try to resolve the issue. So this is kind of the form that you would use. And again, if there is reason to expedite, if there is important that you indicate that expressly in these documents if there is a time constraint. Okay, and so in the interest of time, we can go through the other CRCL one fairly quickly. And so I also encourage you to kind of take a look at the CRCL, and you can filing a civil rights complaint. And so it is not, as I said before, it's not just within USCIS, but within ICE, it is a complaint process that you can use about detention issues, access to medical and mental health care, use of force or any kind of sexual abuse issue, so that they also kind of investigate due process issues or kind of any allegations within ICE. You can make a complaint. You can make a complaint against CBP regarding profiling or proper searches or any kind of asylum seekers at the point of entry are all kind of issues that you can raise. Here, it's the Violations of Confidentiality and Violence Against Women Act, and if you go back up, Amy, to the compliance section, if you go to, right, they have a specific process which you can kind of use for doing VAWA confidentiality, which you can also find on their website. So if you scroll up, and okay, if you go to, yeah, exactly, right there. And so that is kind of the process by which that you can kind of, you can either use their form, they have a kind of optional form that you can use, or oftentimes what people have done is just write letters outlining what the problem is and what the allegations are, and kind of taking what is the problem that you're seeing. So this is the way that you've done that before. So, okay, if we want to move ahead. All right, thank you. So for our next slide. Great, thank you. So we're going to go, maybe kind of do every other poll here. So what we're seeing here, we have a client, Claire, who filed for an adjustment application, but she might also have a permanent bar issue, right? So we filed the 601 and 212 concurrently with the application. So the self-petition was approved in May of 2018, but we're pushing on 2 years later, and we still don't have a notice for her adjustment interview. What do you do? Check as many as you think would apply. Would you just keep on keeping on? Would you file a USCIS case assistance request? Would you try to get an info pass at your local office once that becomes a thing again? Would you contact your client's congressperson? Would you do us? Get a technical assistance for us? We kind of, and I'm really glad here to see that people are pursuing multiple options. And I know that can be time intensive. but you don't know what is going to be the thing to make it stick to the wall, right? So I feel like, pursuing maybe multiple options or knowing that you have a menu of options to pursue these types of issues, I think is basically kind of what we want you to come away with, is that you do have a menu of options, several options, when you're dealing with these sorts of processing delays. All right, if we can go to the next slide, next poll. So we have our adjustment interview, okay? You waited 2 years, and let's just pretend this was back in February. Denies her I-212 on the basis that she didn't remain outside of the United States for 10 years. And so as a result of the denial, you're also denying the 601 and the 485. What do? You do nothing because USCIS is right. Would you file a 290B? Would we contact the USCIS Ombudsman, contact us? What would we do here? And right, I think, so here I think I'm very glad to see that zero of you would do the first one. That is very heartwarming to me. Secondly, I think that 83% of you are right on, that you want to make sure that you are safeguarding her administrative appeals options, that you want to make sure that you are preserving her rights and addressing this legal error on appeal. But also, I think you are wholly within your rights and opportunities to kind of say, hey, there is a serious legal error here, and we want to make sure that you are put on notice of it, either vis-a-vis the technical assistance through ASISTA and our liaison work, and after reaching out to USCIS directly, maybe sending something to the hotline or otherwise, utilizing the CIS Ombudsman as well if you find it necessary. And then a few of you to kind of do maybe some media work as well. And I think that, that obviously, I think because of confidentiality reasons and others, requires discussion with your clients and making sure that, people are aware of that. But I think that that is something that people have certainly done before. Okay, should we go to the next slide? Okay, we have the denial notices, but we notice the address on the denial lists her abuser's address, even though we have a safe mailing address. And we also believe that there's a copy of the denial notice to her abuser address. And what do we do here? I think you're right on. I think that, the option that you're going to kind of say, hey, maybe raise this up with your district director, or raise this up kind of saying like, hey, something happened that shouldn't, right? And then if you don't get a good result there, then making a complaint with the Office of Civil Rights and Civil Liberties is something that I think is absolutely worthwhile if you have reason to believe that they should investigate this matter further. And again, I know that only about 3 of you responded, but you can also reach out to us if you want kind of considerations for how this would work in the context that we kind of our approach and guidance. If you're always welcome to seek that as well in these cases. Okay, next slide. I think in the interest of time, we're just going to go on to why don't we do about notices going missing? I just think because we have such few times. So why don't we just move ahead and close this poll? But I think you get the idea in terms of which agency you can reach out to in which circumstances. So, all right, go ahead.
Okay, so in the time we have left, let's go through issues that we've been seeing with USCIS notices that are going missing. Quick poll. In the last year, my clients have experienced select all that apply. Did not receive an RFE or annoyed that USCIS says was sent to you or to them. Your client did not receive a receipt notice, an approval notice, or a denial notice that USCIS says was sent. Did not receive an EAD or a green card that USCIS says was sent. USCIS did not receive documents that you sent to them, or other administrative problems relating to missing documents. Let's just give it just a couple of seconds. Okay, yeah, it seems like people have had kind of all of these issues. For those of you who said other USCIS administrative problems, do you want to put in the chat box what those other problems have been? And as we go through this section, I can just kind of see what other issues people are having. So let's go ahead and end this poll. It gives me a sense, but essentially, yes, what you are seeing is not abnormal. Very unfortunately, we have seen an uptick on, actually, if we can close out that poll and go to the next slide. Great. So what we are seeing is that these are current trends, non-delivery of RFEs that are resulting in denial for abandonment. We are seeing non-delivery of EADs resulting in loss of employment, time-consuming to resolve these issues, so your clients may end up without employment for a while before their employers will take them back with some kind of proof that you get from USCIS. USCIS is losing previously submitted documents. And what we've seen here is both documents that were submitted at the time that the case was filed and documents that were submitted with the RFE. Maybe you get a denial notice saying this is what you sent with your RFE, and that list that USCIS includes in the denial doesn't actually reference some of the other evidence that you submitted. So we are seeing these issues. These are the current trends. So what can we do about them? Just kind of general suggestions. I know many of you already do this, but it's always good for us to review these kind of general guidelines for those of you that may not have already been doing this. Sign up for My Case Status or My USCIS at uscis.gov. Which should give you updates or allow you to get updates on any action that is taken on a particular petition or application. It may not be able to give you access to VAWA or U case information. Sometimes what people have seen are a notice was sent. They won't tell you what kind of notice. They won't tell you exactly what was asked for, et cetera. But you may be able to see kind of some of the information. Always follow up immediately if you're not getting that information. So follow up with Vermont Service Center or with Nebraska Service Center if it's Nebraska that has the case pending. Make sure to keep your office address up to date and make sure that your staff are handling mail properly, right? So if you have a new staff person, go through the mail handling process, you know, whatever your procedures are internally for what they do with mail as it comes in, how to get it either in the electronic file that you guys maintain or the paper file that you guys maintain, depending on what your office procedures are. And in terms of updating your address, if your organization has different addresses, make sure that USCIS has the address where you as attorney of record or as the advocate are receiving the mail on that particular case. If a client provided their addresses, remind the client to check the mailbox and let you know of the notices. So if for some reason, you know, maybe the client filed on their own before you started your representation, make sure that your client continues to check even after you submit your G28 with your application. I'm sorry, even after you submit the G28 with your address, sorry about that. Okay, if you discover that an RFE has been issued and you haven't received a denial yet, contact Vermont Service Center or Nebraska Service Center immediately. Request the issuance of the RFE and ask them for a new deadline, right? Because we know as soon as they issue the RFE, that clock is ticking. And in most instances, we've been seeing that the RFE response time is already the maximum amount of time allowed by regulation. So what you really want them to do is not extend that time, but just start the clock over. Have them give you a new deadline based on when you're actually receiving that RFE notice. USCIS may reissue, but what we're seeing, even though you should ask for it, what we're seeing is they sometimes just give you the same deadline. The reason you want to ask for it anyway is because if you end up having to file an I-290B appeal to the AAO or a motion to reopen and you're asking for a supervisor to look at this case, then you want to show, that you made the effort to show that you hadn't received it, to request the new deadline, and why the new deadline was the appropriate way to go. If you receive a denial for abandonment, you have to file that I-290B motion to reopen timely. Remember that when it's a denial for abandonment rather than a denial on the merits, the regulations require that the I-290B be a motion to reopen rather than an I-290B appeal. And so this is important, and this is why we want to make sure and track this as much as possible. And in addition to filing your I-290B, also do the advocacy, because your client is losing out on actually getting any kind of review on the merits of the actual case. So despite your advocacy efforts, you still have that I-290B motion to reopen deadline, and you don't want to miss that deadline while you're doing your advocacy. So do both at the same time. Include any evidence that you that was requested in the RFE. Once you actually get a copy of the RFE, just include the evidence in your I-290B. So hopefully they'll reopen and actually give you a decision based on the merits of the actual petition or application. At the same time, in addition to doing all the great advocacy that may be appropriate and that Cecilia discussed, file a FOIA on your client's case. And in addition to just the general A-file FOIA that you would make, we're also asking everyone to file a FOIA for ECHO claims or CRIS records. And these are electronic records maintained by USCIS, and electronic records are part of the A-file. So what does this mean? We've referred to this before, or started referring to it about a year ago, as a keystroke FOIA. Each of these ECHO claims and CRIS records, those are databases maintained by USCIS that control different parts of actions that USCIS officers take on your client's case. And so there should be a keystroke for issuance of an RFE, and then a separate one when the RFE is actually mailed out. So trying to get a FOIA on what keystrokes were actually entered in your client's case would be helpful to show whether or not the RFE was actually mailed out, and perhaps also just in the course of your regular FOIA results, perhaps it'll also show that if it was sent out, it wasn't sent out to you. Okay, and then in terms of missing notices and documents, if the EAD is being sent to your client, make sure that your client understands how to check for USCIS missed delivery notices. For missing notices, of course, email Vermont and Nebraska, FOIA the file. As an absolute last resort, you can file an I-24, which is to get a duplicate approval notice. This is not the process for getting a new I-94 issued. So if that's the missing document, this is not the way to get that, unfortunately. But if it's an approval notice that you need, then this is the way to get it. Unfortunately, it will cost. There is a filing fee. It's time consuming. It's not the best way to go. But I know in some cases, you've tried everything else and your client just needs that approval notice, so you may have to resort to this. I know we're over time. But I do just want to, I'm going to go ahead and just skip to the part of let us know, particularly if you have a missing RFE, in other words, an RFE that was sent by USCIS to you, you didn't receive it, and as a result, you either get a denial and you have to file an I-290B, or you get a denial, the I-290B period is over, and you're actually up against potential NTA being issued. Please contact us as soon as this happens. We are advocating. We have many examples. We're advocating with USCIS, with CRCL, with the Ombudsman's office. They are aware of this issue, but the more examples, the more concrete examples we can give them, the better chance that they can just pinpoint what the problem is internally. Clearly there is an internal problem, but we have not gotten a response as far as what is that problem. Is it one of their particular databases or systems? But the more examples we can give them, the more they can maybe hone in their resources on figuring out where the problem lies. So please do let us know. Additionally, I want to point out we have a great practice pointer on missing RFEs. And that is included in your materials today. And if you need any other case-specific information on this, please contact us through our technical assistance request. Thank you guys so much for being with us today and for staying on a few minutes longer. Here is our contact information for any one of us, and then in addition, the link to the individual technical assistance. I hope everyone has a wonderful rest of your day, and please do stay healthy and stay safe.
I know that there were a lot of questions in the chat box that we weren't able to get to during the webinar today. So if you guys want to submit them as technical assistance questions, we're happy to respond individually to folks.
And for those who asked whether this is being recorded, it is. And as mentioned before, all of the chat box conversation will also be sent to you.
For CLEs, you can email Maria. I'm putting in the email address here. If you email any of us, we'll just forward it to Maria and get it to the right place. So whoever is fine. Okay, so I think that is it for us today. There will be an evaluation that's going to pop up on your screen when it closes. So if you guys wouldn't mind filling it out and letting us know how we can improve, then that would be great. And beyond that, have a great afternoon, everybody, and we hope you all stay healthy and safe.